Our speaker for today's session is none other than Mr. Mohamed Fazal. So Mr. Fazal is actually an experienced legal practitioner who specializes in various areas of law, including commercial, family, probate, and criminal matters. So with an extensive legal career spanning from 2014, he has represented numerous clients in the High Court, State Court, Family Justice Court, as well as the MUIS Appeal Board of Singapore. So in addition to his legal practice, Mr. Fazal is also an accredited Singapore Mediation Center and Singapore International Mediation Institute mediator, as well as accredited member of the Chartered Institute of Arbitrators. So today, Mr. Fazal will shed light on the topic of pre and post-nuptial agreements, and he will delve deeper into the legal implications, intricacies, and also the significance of these agreements from a civil law perspective. So without further ado, please join me in welcoming Mr. Fazal. Mr. Fazal, the floor is yours.
Thank you very much. Can I sit down? Is that okay?
Yeah.
Assalamualaikum. How's everybody? Thank you for having me here. Thank you for the kind introduction. Yes, I'm a lawyer since 2014. Mostly my work spans family law. So this is an area that I'm very interested in. I do this on a daily basis. Hopefully my objective today is to share as much as I know insofar as prenup and postnup is concerned. More and more, especially before the Sharia court, I see this executed between the two parties, but before the family justice court is always quite popular, right? And I'll explain why. Okay, so in simple terms, a prenup is a document that parties prepare before marriage, all right, which will set out how they intend to divide their assets, how they want to take care of their children and the like. A postnup is a document that you prepare. Mainly what I've seen in my practice is that parties are already talking about divorce. Then they prepare this document at the lawyer's office to really set out the agreement between the two of them. Between the prenup and the postnup, I see more postnup. Why? Because I think on a practical basis, nobody in Singapore, I think, gets married with the intention of having a divorce, right? It's quite not so... it's quite taboo, right, to talk about that between the two parties. Now, I like to talk about the law first. With regard to the law on prenup, postnup, did I just amend this? Okay. With regard to the law on postnup and prenup, it is the same before the Women's Charter and before the Sharia Court. For civil divorces, we apply the Women's Charter. Okay. Right. Yeah. Section 112, it's a glass screen, so sorry. Here. Section 112 of the Women's Charter says the court will take into account any agreement made between the two parties. All right. And you will see in AMLA, before the Sharia Court, we don't apply Women's Charter. We apply the Administration of Muslim Law Act. Right. In that particular act, it is, you will see here, it's a mirror provision. It's word for word the same towards how the court will take into account towards any agreement between the two parties. All right. So I would say, as a lawyer, where if Muslims were to do a postnup, it is equally applicable or enforceable before the Sharia court as well as before the family court. Okay. Now, with regard to the benefits of preparing these agreements, and I suppose when I talk about these agreements, like I said earlier, I see it more common for postnups. And the idea of it is that both parties agree to put into paper the agreement, what they like to have if they were to have a divorce, right? Typically, how it works, maybe if I try to set out the procedure at court, okay? Let me focus on the family court first, okay, for our non-Muslim friends. For, if parties will prepare a postnup, that means the idea between the two of them is to prepare a divorce on a simplified basis. In Singapore, you can have a divorce by 3 ways. The first is, I'm still talking about civil divorces, okay? 3 ways. The first is what we call a simplified divorce, whereby in pursuance or after parties prepare the agreement, they already know that they want to have a simplified divorce. They come to the lawyer's office to effect the documents for simplified divorce. Lawyers will then prepare it, we file it to court. Nobody needs to go to court. The idea of it is to make it as simple as, as simple as possible, maybe less acrimonious as possible. Okay. If parties don't do that, with regard to the postnup, then lawyers would then need to start the divorce on a contested basis, right? Of course, through the Family Justice Court, the mechanism would be the judge will have a mediation session and all that with the aim of having an uncontested divorce. But you will see that the agreement, if prepared, would eliminate all these fights between the two parties. All right. But for the Sharia court, there's no such mechanism as a simplified divorce. If at all, parties prepare the post-nup with the idea that they're going to comply to that agreement. Then the plaintiff will prepare the case statement to set out or to flesh out the agreement that parties have had. The other party, having received the case statement, will prepare the defense, also in reflection of the agreement. Then parties agree at mediation. But the idea of it is to have it resolved amicably, right? Except that before the Sharia court, you still need to go to court lah. But for family court, simplified divorce, you don't have to. But there's still a mechanism lah before the Sharia court. But the idea of it is that we want to provide financial certainty between the two parties. Why? Later, I'll explain later. But really, towards the post-nup, what is important, lawyers will set out, is the agreement with regard to the division of assets, with regard to the children, with regard to the maintenance of the children. These are all going to be discussed lah between the two parties. Of course, practically what happens is that, let's say, for example, hypothetically, my client comes to me. He says that I want to prepare this post-nup, right? Of course, I'll take instructions. We will need to advise what are the facts of the case, what is his proposal and all that. And then we will then typically, if he wants me to send a letter to the other party with regard to the terms, then of course we will set out those terms and then parties sign that particular document. But then with regard to everybody, I mean, since everybody is here, with regard to if you were to think about wanting to also prepare the post-nup, you also need to know what are the rights that you are trying to secure, right? Later I'll go through in greater detail later. So besides financial certainty, you also protect your you protect yourself with regard to each other's debt. Under law, there are some occasions whereby you are responsible for the other party's debts as well, right? Let's say, for example, if you purchase a car, for example, right? The guarantor typically will be maybe you, and then the spouse, your spouse is the guarantor, right? You then need to set out the agreement to then limit your exposure, that kind of thing. Similarly, you will also be able to safeguard your family heirlooms or businesses. I'll go through in greater detail later. But again, like I said earlier, the idea here, the most important thing is to have an amicable divorce because they have already agreed to the terms in the agreement. Okay, now it gets tricky a little bit. The law says, the law says that if you look at section 112 and 52.8 of AMLA, it says here the court takes into account any agreement, right? However, there are some cases where the court doesn't enforce the agreement, okay? Which is especially why it is even more important to also know when the court doesn't enforce these orders. Why do I say that? Because for all your effort in wanting to have an amicable divorce, you put into terms that are not enforceable, the court will then say, I'm not going to rely on it. Then it creates even more problems, right, between the two parties. And I'll explain the differences later. Yeah, but it's an interesting area of law, lah, so to speak. Maybe I should say it this way. If you see, sorry, one moment. Okay, like I said earlier, section 112 of the Women's Charter is the same as 52.8 of AMLA. All right. Later, or maybe even your phone, you can just Google the particular legislation that applies to you. But the nub of it is that, let's assume, if I refer everybody to 52.8 of AMLA, right? Under section 8, there are other factors that the court takes into account, right? Do we want to go to, okay, tak apalah. You just go to your handphone later and check. Subsection 8 is only one of the limbs of AMLA. There are A to E, I believe, where the court must take into account other considerations. So let's say, for example, if the agreement doesn't take into account the other provisions, the court will then say, I'm not going to rely on it. Fundamentally, what is unique about family law, it is not contractual in nature. If you really think about it, this is a contract, right? So contracts are enforceable in law, right? But because it's a family area of law, the court, if it feels that it is not fair or just and equitable, what we commonly say in the field of family law, the court will not allow parties to enforce the court order. There are cases that the court sets it aside and then makes orders afresh. Okay, so this is quite important. Like I want to reiterate, for all your effort in wanting to put into writing, if it doesn't address the issues, then the court will not rely on it, and then makes it even more worse, like, to my experience. Okay, so as I was saying earlier, you look at the no problem. Okay, no. So, okay, so like I said, I want to re-emphasize the fact that these agreements, prenup or postnups, although they provide some certainty, they are not an absolute guarantee. Okay, this one I'll keep on re-emphasizing this. Okay, so as I was saying earlier, whether or not prenups or postnups are enforceable in Singapore, the nub of it is that the court can review and reject the agreement if it thinks that it's not just and equitable. Just and equitable is a legal term. If you look at under the Women's Charter or under AMLA, there's no definition of what just and equitable is. It just depends on the facts of the case, right? Which makes it even more unique, right? So that's number one. The court can also set aside the agreement if one party is, of course, put under duress, undue influence, or coerced into signing the agreement, right? So legally speaking, there are 4 ways that the court can set aside this agreement. And I was saying earlier, the court also balances the other factors set out in section 112 of the Women's Charter and 52.8 of AMLA. Okay, later you guys look at it lah, depending on the facts of the case. Now, maybe I jump to here first lah. Okay, maybe I'll do this first. With regard to the tips I want to share first, if you were, of course, if you are thinking about having a divorce, or if your friends are thinking about having a divorce, I always advise my clients how you want to end your marriage. To me, people get married on good terms. They ought to also part on good terms, right? So post-nups agreements are a good way to have a divorce on this basis. Of course, that implies the other party is as reasonable as you, right? Sometimes people are, sometimes in family law, especially when emotions are quite charged, people are not always reasonable, right? Unfortunately. But of course, I always tell my clients, how the other party reacts, you cannot stoop to that level. All the more you should be reasonable people, right? And try to engage. So that's number one. Number two is that if you were to intend, this is a cop-out answer, but the nub of it is that if you intend to prepare post agreements, always consult a lawyer. Why do I say it? Later I'll go through the terms of the agreement. But then the reason why I suggest this quite strongly is because, especially when the other party is having a lawyer, it is not wise to do it on your own. There are, one moment. Okay. There are some cases which I've seen before the Sharia court and before the family court. One party has no lawyers, the other party has lawyers. Sometimes the court would still, although the court has mechanism to ensure that parties really agree to the terms of the divorce, but the court is not vested or responsible for whether or not you have a good order, right? So typically what I've seen is that these clients will then realize, hey, I pretty much got quite a bad result. They come to lawyers expecting some form of ability on our part to set aside the order. It is an impossible task. Under the law, if there's consent order, it is almost impossible to change. You cannot appeal against a consent order. A consent order is an agreement whereby parties confirm the contents, and then the court records it as a consent order. You see? But yes, it is always impossible. By then, it'll be too late already, right? So as I was saying earlier, with regard to the and on a related point, oftentimes I've also seen some cases whereby one party don't engage a lawyer, but then he signs the agreement, right? By that time, they appear to court, they then realize, okay, maybe I've signed it wrong. I want to, what they call it, change. And then they engage a lawyer. I just did one the other day whereby my client went to the other lawyer's office, signed the agreement. The agreement wasn't really fair. He then comes to me and say, I want to set aside the agreement. It is possible lah. You need to have skill lah to do that, let me put it that way. But to me, it is a bit unfortunate because you start from zero, you start from square one with regard to the discussion between the two parties. You might say and speak to a lawyer as soon as possible, so that parties, when they execute the agreement, it's for amicable divorce, right? Because if I were to, I mean, on the case I've talked about, now what I need to do is, beyond the facts of the case, I need to convince the court why the court cannot put weight on the settlement agreement. You see, so that creates an element of acrimony between the two parties, right? Because you would imagine, one party would already spend some legal fees in engaging the lawyer to prepare the agreement, right? So all of this is not wise lah. So let's do some case. Am I going too fast? No, okay, smart people. So I want to cover two cases, right? At least with regard to today, there are more cases, of course, that has been heard in Singapore. These are the recent ones that I want to share. Two Court of Appeal cases, okay? One in 2009 and the other in 2016. Now, in TQ and TR, the slides will be given, I hope, to you guys, where I've already given the summary of the case, so this is easier to read. But the nub of it is that in TQ and TR, the court parties executed prenup, right? With regard to the agreement that parties have executed, it concerns the care and control arrangements for the children. Okay, what the law said with regard to prenups, with regard to this kind of agreement, is that by default it is unenforceable. By default, unless you can prove that it is in the best interest of the children. Okay, so the starting presumption is that it's not going to be enforceable unless you prove to me, to court, that it is in the child's best interest. So you will note that in spite of the agreement that I shared earlier, in spite of the law here, that any agreement the court needs to put weight, right? The court really, once it's contested, there's already starting presumptions ready. Because, let me put it this way, of course, in this particular case, in TQ and TR, parties already didn't agree to the agreement. Then they needed to contest. One party would say, I want to have the agreement enforced. The other party would say, I don't want to have the agreement enforced anymore. Then it's up to the court to then decide whether or not the agreement is to be binding upon the two parties, right? So in this particular case, the court said, once there's a contest, I don't need to, the law is, the agreement in and of itself is unenforceable unless you can prove to me that it is in the child's best interest. You see? But of course, had the matter been heard differently, whereby between TQ and TR, they agreed with the agreement still, then of course there's no more case, right? Parties agree to the terms, right? But in this particular case, because there's a dispute already. Okay? In the other case, in AUA and ATZ, in this particular case, the court upheld the agreement between the two parties. And in this particular case, it was more about the asset division. And in this particular case, the court found that because of the fact that parties had been entering into a lengthy negotiation, also had lawyers, the other party in coming to court and say, I don't want to be bound anymore, the court didn't allow that to happen. Because of the fact that they already had such an extensive agreement for them. Okay? So these are the things that I wanted to, these two cases, especially with regard to what I wanted to cover, at least to give a flavor of what the agreements are. Any questions so far? Can Yes, ma'am. Of course. We will probably share the slides.
We will record the whole presentation.
Of course. Yeah. Sorry, this slide is supposed to be together with this slide. I must have jumbled it up. My apologies. Okay, so now I want to talk about the nitty-gritty, if I can be allowed to have some time to talk about that. Now, typically, an agreement will cover the following. Okay, of course, it depends on whether or not you're a Muslim or non-Muslim. Okay, the first is the division of assets. Okay, this part, if you look under the provisions under the Women's Charter or AMLA, it says any asset acquired during marriage, whether or not it's jointly held or solely held, it becomes a matrimonial asset, liable for division. Sometimes I've seen some people, maybe let's put it this way, a housewife, right? 10-year marriage. Husband is the one that has been working. Of course, maybe the house is held under joint tenancy between the two parties. The husband, who is the one that is working, he has CPF assets. Legally speaking, under this provision, the wife can claim a share of those assets as well, right? Similarly, let's say, for example, pre-marriage, right? The husband maybe has a house ready that he has acquired during before marriage. And then after he got married, the wife stays with him, right? Technically speaking, even if the husband continues to hold the house under his sole name, because of that, because of the fact that the wife had been contributing towards the household, legally speaking, they are still claimable. Okay? To me, not a lot of people know this, and I think it's unfortunate because the wife ought to be able to claim, right? Similarly, of course, it works both ways. If the wife having this house is the husband that moved in, somehow he can show to court that he had contributed, then of course it's claimable. The only issue here is the extent of division, right? Whether or not the court divides it 50-50 or 80-20, that kind of thing, right? Also on this point, right, there's certain presumptions in law. If the marriage is very long, right, and where the husband is a sole income, the family is sole income, the wife is the one that is a homemaker. If the marriage is very long, the court tends to divide it 50-50 between the two parties. Why is it like that? Because the court recognizes that the person seeking money is as important as the person taking care of the house or the household, right? So the court divides it on those bases with regard to the presumption. But if the case is not about the husband is a sole breadwinner, it's not a long marriage also, there's no such presumption. Okay? There's this other case that the court applies, what we call the ANJ and the ANK approach. Let me give you a quick example, okay? Let's say, for example, Tom and Katie, right? Both of them are working during the marriage. Marriage is for 5 years. The court, insofar as the matrimonial house is concerned, the court first looks at direct contribution. Direct contribution is by way of CPF or by way of cash. If you pay for mortgage or you pay towards renovation. Let's say, for example, for hypothetical scenario, right? Tom pays 60%, Katie pays 40%, right? So by direct contribution, 60-40, correct? Because of the fact that it's not a contract, it's a family issue, it is not always about person who pays more. The court also takes into account indirect contribution. And that is with regard to, in Malay, titip perlu lah kira, or day-to-day effort. It also depends on how many children there are in a marriage. It depends on whether or not the husband who pays for the conservancy, who pays for the groceries. Because for indirect tuition, for indirect contribution, there are two parts: indirect direct contribution or indirect non-financial contribution. Right? One is really effort. The other one is paying for the day-to-day living expenses. But the nub of it is that the court will also ascribe a percentage for indirect contribution. So let's say, for example, just now 60-40 kan for direct contribution, maybe for indirect contribution, the court awards 60 in Katie's favor. So the final result will be 100-100, right? The court then applies the average ratio, right? Then the court will then say 50-50, right? But then under the law, the court can also adjust the weightage. If there are young children to the marriage, the court can then still make adjustments to take into account the child's needs. So my point here is that it is even more important, right? When you want to agree to a post-nup, with regard to telling your other party that, look, I want to have this house divided in a certain way, what methodology are you applying, right? Of course, between the two parties, you can agree to whatever lah, right? But is it really fair for you? That's my point, right? You need to know this law to then decide, okay, look, my baseline is X%. Anything lower than that, I am giving too much. You know what I'm trying to say? Or I'm giving too much to another party. Because to me, as a family lawyer, I'm always cognizant of the fact that even if the parties were to have a divorce, unfortunately, then for what it is worth, you also need to get fair outcome to then continue on with your lives, right? It is not, fundamentally, it is court of divorce, right? It is not about the court ensuring one party to walk away with everything. It's also quite impossible. The court also has to apply some methodology to it. It's just a matter of me sharing the law so that everybody understands. Can I? Now, with regard to maintenance this is only unique towards non-Muslim marriages. Okay, under the Women's Charter, the wife can ask for maintenance if the husband is being sick, what we call in law, being unable to take care of himself. He can also ask for maintenance against the other party, against the other wife, so to speak. And children under 21 years old, that's also going to be decided before the family court. Okay. Of course, then you need to have a discussion between you and your spouse, who wants to have care and control, custody, and all that, because typically the person having care and control has a right to ask from the other party to contribute maintenance. You see? So maybe I go on to the next point. With regard to the children's issues, it's always three things: custody, care and control, and access. In law, the court starts with joint custody. Unless you can prove to court that the other party has abused the children, right? But the idea before the court is that they want both parties post-divorce to be still involved in the decision-making process of the children, only limited to 3 things: education, medical, and spiritual. Of course, in a Muslim setting, it is quite hardly applied, right? For Muslim, we are going to raise our children as Muslims, but for non-Muslims, sometimes one party might be a Buddhist, the other party might be a Christian, then there might be some discussion as to how to rate, what religion to have to have for the child, so to speak. So that's custody. Care and control is who takes care of the children. Okay, access is the person not having care and control gets to have access lah, right? So you also need to talk to your spouse. How regular is the access? Is it every week, or is it on an alternate basis? What time to what time? These are the things that must be put into the agreement. It's just a matter of, do you know what joint custody is, what care and control is, what access is lah. I think that's important for you to, because you cannot put pen to paper on the things that is foreign to you, isn't it? That just doesn't make sense, right? You need to know what these concepts are before you even suggest to the other party. Yeah. Of course, in a Muslim marriage, of course, there are then certain issues of Eda and Muta'ah, right? Of course, with regard to Eda and Muta'ah, of course, Eda, I still encourage everybody to know what nafkah Eda is, what Muta'ah is, what are the considerations where the court considers to award Muta'ah or Eda, which you will then need to put into paper lah, to suggest to the other party. So far, so good. Okay. Then, of course, I say this because I've seen some attempt by parties. The law in Singapore is that you don't have to have a lawyer represent you in court, right? Not necessary. Especially with AI now lah, or maybe even Google search, you can find some templates, isn't it? Online with regard to a prenup or post-nup. But I always tell my clients, don't always use a template because it might not be applicable for your case, right? Okay.